Welcome to the Veterans Legal Lowdown, a podcast about VA claims and appeals by Chisholm Chisholm Kilpatrick. In today's episode, we're going to be discussing four important topics, including special monthly compensation or SMC benefits, back pay or retroactive awards. We're going to be discussing dependency claims. And finally, we're going to be discussing tinnitus, including proving tinnitus through secondary service connection. Michael Lostritto, partner here at Chisholm Chisholm Kilpatrick, and today I'm joined by Dallas Aguiar. Dallas, why don't you tell us a little bit about yourself?
Hi, so I'm Dallas Aguiar. I'm an accredited claims agent, and I've been working at CCK for 7 years, and I'm really happy to be here today. It's my first podcast.
Oh, that's great, Dallas.
Yeah.
I'm looking forward to it. This is going to be great. So before we get started, remember to like, subscribe, share. We try to address veterans' questions in the videos, so please feel free to leave comments, but just remember, don't leave any personal identifying information or health information so that the whole world can see your information. Dallas, in this segment, we're going to be talking about one of the most valuable and frankly misunderstood benefits that VA offers, special monthly compensation or SMC. Very briefly, SMC benefits are a benefit that's available to veterans to provide additional compensation above and beyond what the veteran's combined rating allows for. SMC benefits are not assigned like regular VA benefits. There's not a percentage assigned, as is service-connected disability compensation for another type of condition. SMC benefits are based on really severe and exceptional circumstances. Very specific levels are assigned for different types of functional loss. And so SMC can often become more relevant as a veteran ages or their disability progresses, just by the very nature of the fact that that typically is when a veteran's condition worsens and therefore allows for the higher level of compensation that SMC is intended to compensate for.
Right, yeah. And the legal authority governing SMC is 38 U.S.C. Section 1114 and 38 CFR 3.350 through 3.352. And in reading these, you'll see that SMC rates are designated by letter. For example, L through O, R1, R2 for aid and attendance at the highest levels. But I want to make a point to note that not every letter in the alphabet has an SMC rate. There's not A through Z. And just because there's a rate assigned for L, it doesn't mean that that would be less than another rate. For example, it's not like corresponding. So like you see S and you might think, oh, that's a really high rate. That's actually lower than L, which comes first in the alphabet. So just want to be clear about that.
Yep.
VA is supposed to consider SMC when it's raised by the evidence pursuant to Akels v. Derwinski.
Do they always do that?
No, they don't. So a lot of times it's on us or a veteran to get VA to look at that. And you can claim it explicitly, but we always try to raise it first. And there are several levels of SMC that include loss or loss of use. And this happens when there is actual loss of a limb, for example, or loss of use, which is a severe disability. It's paralysis or weakness that basically renders that limb no longer functional for practical purposes. It's very severe. And the most common SMC terms we see, and you'll hear us talk about today, are aid and attendance and housebound. You may have heard these before and not even realize that these were SMC rates. Yeah,
these are very, very popular. And as SMC goes, maybe more common.
Yeah.
That we see in our practice here. So I know we're going to go over that and get into that a little bit more later on. But I think first, let's talk about the types of disabilities, and there are numerous, that most often lead to SMC. This is not an exhaustive list, but this is, I think, a good general list. The first, as you mentioned before, physical loss or loss of use, right? So here we're talking about the loss of limbs, the loss of an arm or loss of multiple arms, or loss of parts of an arm or leg. We see amputations from the knee down or from above the knee or from, a hand or finger. Loss of use, on the other hand, again, as you indicated before, the veteran hasn't physically lost an appendage, but they have lost the use of that limb, right? And so VA often will treat that the same for purposes of awarding SMC. The other is vision loss. And so we see that I see this at least a little less frequently, but nevertheless, it does happen. Veterans have severe visual impairments and blindness, sometimes visual acuity of 50/200 or less in both eyes. And so SMC is awarded in circumstances where a veteran's vision loss is just that, it's a loss. And so under the law, under the regulations dealing with SMC, VA has a system in place to compensate accordingly for those.
And a couple more examples, more severe or very severe, I would say, is traumatic brain injury residuals. Traumatic brain injuries are really intense. They can cause a number of different residuals. So there is also, you could qualify for SMC at some of the lower levels, but there's also a higher level of SMC at the T level that is specifically for traumatic brain injuries. And another one is being bedridden. This is governed by 38 CFR Section 3.352A. And direct quote for you, Mike, this is a condition which, through its essential character, actually requires that the claimant remain in bed. And I'll note that voluntary or prescribed bed rest doesn't suffice for this type of benefit.
Yeah, this is, again, SMC, think of the most severe, exceptional circumstances for veterans, unfortunately dealing with loss of functional use. So all those things that you just said. Continuing on, another category of conditions are neurological conditions. And so think of diseases such as ALS, MS, Parkinson's disease. If you've ever known someone that unfortunately has this or any of these, very disabling, very disabling. And so SMC is awarded oftentimes based on those conditions for the functional loss that those conditions impact the veteran on a day-to-day basis. One thing to note, mental health conditions often kind of get wrapped up sometimes with neurological conditions, although separate. SMC isn't often awarded solely due to a mental health condition such as PTSD, at least from what I've seen. What typically happens, though, is a mental health condition will impact a veteran's ability to perform everyday living activities, right, or ADLs, as VA calls them. And so when that happens, a veteran's mental health disability can lead to the award of SMC by virtue of the fact that their PTSD or severe depression or other mental health conditions prevent them from being able to care for themselves and need a third-party caregiver. So just something to note. We see that frequently. Right.
And so Mike mentioned a minute ago activities of daily living. So I want to talk a little bit about aid in attendance and housebound status. So first off, aid in attendance, or A&A. This is available when a veteran needs help with their activities of daily living due to their service-connected conditions. This could include bathing, dressing, feeding, toileting, or adjusting prosthetics. There are also, this is usually compensated under SMC-L, but there are higher rates of SMC that you may qualify for if you have the need for aid in attendance plus some other things going on. Now, housebound status, there's two ways to qualify. First, most straightforward is being housebound, right? That's where we get the name. But also, you can qualify for housebound status if you have a disability that's rated at 100%, and then your other service-connected disabilities combine to 60% or more. This would also work if you have a award of TDIU, or total disability based on individual unemployability, and that's based on one service-connected condition. But then again, you have other conditions that combine to 60% or more.
So Dallas, like an example of that might be if a veteran has an award of TDIU, and as you said, that TDIU is based on, say, exclusively service-connected PTSD.
Very common. We make that argument. And you might see other conditions that combine to 60, which could be maybe sleep apnea at 50 for a CPAP machine, and then tinnitus at 10. And that could be enough in cases like that.
That right there is your path, perhaps, to SMC at the level S.
Yeah, exactly. And if you want to file for SMC, including for these two types we discussed, you want to include in your filing VA Form 21-2680. This is the examination for housebound status or permanent need for regular aid and attendance. And if you were scheduled for an exam, this is the same form that the examiners are going to use, or a similar form. You can also submit some statements from your caregivers providing details of the assistance that they're providing you. And if you have them, some treatment records, some home health records, or occupational therapy notes too.
These cases, I think it's fair to say, are often quite complex, right?
Yes.
And so veterans should not assume that just because the benefit is warranted, VA will independently recognize that it's warranted and then grant it whenever it appears in their file, or the evidence supporting such should appear in their file. Although VA does have an independent requirement to, if the evidence shows in a veteran's file that a certain level of SMC should be granted, grant the benefit, they don't often do so, or they don't always do so. And so it's really incumbent upon the veteran or the veteran's accredited representative to scour the file, make sure they're looking at every independent basis for awarding SMC and for raising the issue and arguing the issue with supporting evidence whenever it's applicable in their case. If you have any questions about SMC, please feel free to reach out to an accredited representative who is well-versed in SMC, all levels of SMC. Be sure to ask whether the representative is well-versed in SMC, and make sure that they are looking through your file, raising it when necessary, and arguing it to get the benefit granted for you. If you have an active VA claim or appeal, then you need to understand the concept of back pay. So what is back pay? Generally, back pay involves a retroactive compensation owed to a veteran for the time between when the veteran filed their claim for a particular condition and when that claim was granted. Now, this sounds straightforward, but there are many permutations of this that make it a bit more complex. And so, Dallas, can you begin walking us through 5 things that veterans may not realize are involved with calculating back pay and what goes into that?
Yes. So as we're coming into the new year, this is most relevant. I think we can talk about the cost of living adjustments. These typically roll out in December before a new year. When you receive some back pay, it's important to note that VA is not going to pay you the rate right now for all these years.
Right.
So as an example, if your claim dates back to 2018, VA will pay you the 2018 rate for that year, the 2019 rate for that year, and so on until the date of your decision. And if you're curious about how this is going to flesh out when you receive a retroactive award, you can go on to va.gov and use their VA rate tables, or have a look at online calculators to estimate what you might be owed, which we do have one on our website.
We do, and it is quite helpful, if I could say so.
Yes.
But there are many out there, and CCKs is a free tool available to veterans and others who would like to log in, input their effective date, the rating, and there are a few other fields.
Dependence,
regarding
I think, too.
Exactly,
Yep.
dependence, and how that calculates into what the back pay is. And all of these things then are calculated, and it spits out an estimate as to what the veteran's back pay will be. It's a really great free tool for veterans to check out.
Yeah. And another important thing to mention is, what's your effective date?
Yeah, critical, right?
Yeah,
Yep.
That's where it all begins. So a major factor in back pay is your effective date. And an overlooked way to ensure a favorable effective date is by submitting an intent to file. And this is a super easy step you can take. And you can do this before you're ready to file a claim, because all this is a formal notice to VA that you have a claim you want to file. And that's pretty much all you have to say. You don't have to identify what the claim is. You don't have to submit any evidence. All you have to do is send in the form, which was a 21-0966 for reference, and just make sure that you submit the claim, complete claim, within a year of the intent to file. And if you need to include evidence, try to send that in too. But the intent to file is just a good trick that we can use to get an earlier effective date. But again, we need to make sure we hit that 1 year window, because otherwise the intent to file will expire.
Exactly, that 1 year window from the date of filing the intent to file to filing the actual claim, right? So, and the intent to file, I agree, it's a huge opportunity for veterans to preserve the date, the effective date, even if they don't necessarily know exactly, or if they're not prepared yet to file a claim for a specific condition. Like you said, it locks in that date for them for the entire next year to be able to file the actual claim. Now, what happens if a veteran files a claim, it's denied, but then the veteran appeals? Well, this brings us to a concept called continuous pursuit. Now, this is a term of art, so to speak, in the VA world, but really what this just means is that a veteran has, again, been able to successfully and timely appeal a denial of their claim. And this is critically important because what that does in the veteran's case is that it ensures that the original effective date, which is the date, as you said, they either filed the intent to file or then filed the actual claim for the condition, is locked in as the date of the claim or the appeal for when the veteran then perhaps has to appeal their case, unfortunately, several times over the course of several years. When that claim is eventually granted, a veteran's back pay will go back to the date that they initially filed that intent to file or claim, generally speaking. So continuous pursuit is this concept that's important for understanding how much back pay there is, because it allows for veterans' claims to continue on in continuous pursuit of the ultimate goal, which is a grant in the case.
Yeah. And the nuances of continuous pursuit can get a bit complicated. It's not as always so cut and dry as claim, rating, decision, appeal. So I think it would be good to consult an accredited representative if, especially if you're not sure. I mean.
Yep. It wouldn't be the first time that we saw a veteran appropriately appeal their case or submit a claim timely within the time that they have to submit a claim after the intent to file, but VA reject it nevertheless, saying, no, the chain has been broken. There isn't continuous pursuit, and therefore, sure, maybe we'll grant your claim, but you're going to miss out on 5 years as an example of retroactive pay. So we here try to make sure that that never happens, and we can ensure that through various techniques and arguments, we catch those things and raise them to VA to get them corrected as soon as we can. Yeah.
And sometimes when you have a long history and you've been continuously pursuing a claim for a while, you might see in your award that you're going to get staged ratings or different ratings throughout the appeal period. An example of this might be if you filed a claim for PTSD and it's rated at 30% from 2018 to 2020. And then in 2020, you have a higher rating, say 70%. So when VA calculates this back pay, they are limiting it to the rate for whatever applicable period we're in. So for 2018 to 2020, the back pay corresponds with the 30% rate. 2020 to present, it corresponds with the 70% rate. The stage ratings can make back pay calculations kind of complicated, but and especially with the cost of living adjustments that we mentioned earlier.
Yeah, there are so many factors that go into this. Yeah.
So I think what I would say is it's super important to read that decision letter carefully and pay attention to some key details, which are the effective date and the rating timeline, to make sure that you got the correct back pay.
Yeah, absolutely. So I guess in closing, back pay can be for veterans a very large chunk of money that's awarded all at the same time. That's the good news. The bad news, or at least the cautionary news, is that don't necessarily accept what VA grants you or issues you just because it's a large amount. it may be large but insufficient or inaccurate. And we've seen that numerous times. So it's important to, again, consult an accredited representative, take a look at the decision, use the resources, the free resources that are available to you, such as VA disability calculators, the one that we have on our own website as an example, and be sure that the lump sum retroactive pay that's awarded is in fact correct. Keep in mind concepts like effective date. Keep in mind concepts like the rating, stage ratings, cost of living adjustments over time. All these things factor into what might be the accurate amount of retroactive pay that is awarded. Continuous pursuit is another one, as we talked about, that allows for that chain from claim to final grant to be connected over the course of several years, perhaps, that allows for a larger back pay. So all these things combined are important factors that one would want to consider when they're thinking about back pay and whether it's accurate.
Right.
Many veterans don't realize that dependency can increase their monthly compensation award, sometimes by several $100s per month. Oftentimes, veterans do realize that if they are combined at a 30% total rating, dependency is available, but there's often many other factors and lesser known issues that arise during dependency that can impact their award. Today, we're going to look at some of those factors and how they ultimately impact a veteran's dependency award.
So first off, we should probably say, what's a dependent?
Yes, absolutely. That's a good place to start.
So first off, of course, most common, a spouse. This is someone who you were legally married to. And I will say that common law marriages can count, but it depends actually on what state you live in, whether your state recognizes it, and how it's documented. You can also, a lot of people don't know this, you can actually also receive dependency compensation for parents that you substantially provide some financial support for. There are some income thresholds that are set, and it varies based on whether you're supporting one of your parents or both of your parents. And this is obviously subject to change as years go on, but it's important to have a look at that to see if you qualify for the support you give your parents. And of course, children. A child under the age of 18 automatically will count. This is an adopted child, a biological child, or a stepchild. But you can also receive dependency benefits for a child between the ages of 18 and 23 if they're attending a qualifying institution for further education, for example. And finally, permanently incapacitated children can also remain on the award after the age of 18, but they have to have become incapacitated or incapable of self-support before turning 18. And whenever you file for any of these dependents, it's always important to remember you need to send it on the proper form. The form for all dependents is 21-686C, but there's a different form for parents and for school-aged children.
Yeah, exactly. And so as you were just saying, VA adds specific dollar amounts for each dependent that's added on. And so that essentially stacks on top of each other.
Yep.
And so the more dependents that you have, the more money is stacked onto whatever the veteran's monthly award is. And so as an example, a veteran might be rated at 40% combined rating, and they have a spouse as a listed dependent. They're going to receive an additional amount stacked onto the reward for the spouse. Now, if that same veteran has a spouse and a child added, they're going to receive additional compensation, not just for the spouse, but for the child stacked onto that award. And that's all going to be in excess of what a single veteran with no dependents would have. And so just think of it, I think stacking blocks on top of each other is a good way of thinking of it as additional dependents, whether it's a spouse, whether it's a child, potentially a dependent parent. All those things factor in, as you mentioned. Once a child turns 18, this is something that we see often. A child turns 18, they've been on the Veterans Award as a dependent minor child, but the child is continuing on into school,
right,
college, or some sort of vocational school. And so long as the veteran can provide proof, oftentimes a transcript, that the veteran's child who is over 18 is continuing on into a qualified institution, then VA will continue to pay dependency awards during that, during the time that the veteran's child, who is over 18 continues on through school. For that, it's important that veterans know about and file VA Form 21-674.
Right.
And it's a pretty simple form. It's a document that accompanied with the appropriate supporting evidence, like a transcript, will allow VA to, number one, know that the veteran intends to continue the child on his or her award even after the age of 18, and allows VA to take the necessary action to keep the award going uninterrupted.
Mm-hmm. Now, earlier we talked a bit for a while about aid in attendance and special monthly compensation. And a lot of times when we're pursuing those cases, it's actually your dependent who is supporting you to receive that benefit. So if you have a dependent, most times it's a spouse or a child, adult child, that is providing assistance with activities of daily living, you can apply for a special monthly compensation. The dependent's assistance doesn't have to be professional or paid. This is based on the level of the veteran's need. So you can submit a VA Form 21-2680 completed by a medical professional, but you could also submit statements from your dependent, whether it's your spouse or child, for example. And this could end up being hundreds, maybe thousands of dollars more than a regular rating without this added benefit.
Another interesting point, which is often overlooked, actually, is that if a spouse of a disabled veteran is requiring help with activities of daily living, then the veteran may qualify for additional compensation known as spousal aid and attendance. And so the veteran continues to need to be rated at least 30% combined, just like for dependency. But if the veteran is so rated and can show proof that the veteran's spouse requires the requisite help with activities of daily living, then spousal aid and attendance is also available as additional compensation. It's important, though, to note that medical evidence is often required. VA won't often grant this benefit, at least in my experience, on their own without a nudge or without an argument or some additional evidence, because they don't know usually the condition that the veteran's spouse is in. So this is something that veterans should consider, raise, provide medical evidence, maybe a doctor's note or a statement if the doctor will provide one. There's a VA Form 21-2680 that they'll want to take a look at and complete. But really, it requires that the veteran show, again, that the spouse requires regular assistance with activities of daily living. And so lay evidence can be helpful here, medical evidence, and a nudge for sure for VA to investigate and adjudicate it.
Definitely. And let's shift over now. Let's talk about the effective date of dependency. VA can owe retroactive compensation for benefits, including dependency benefits, but there's a catch. The effective date for dependency back pay will either be the date of the event, so this could be birth, marriage, adoption, but that's only if the claim is filed within a year of that event. Otherwise, VA will only begin compensating for that dependency change when you file the request. So it's always important when you receive an award letter to check to see what dependents you're being compensated for. And if you're even being compensated, sometimes you might think when you receive an initial reward that, oh, I'm assuming my dependents are on there. I think VA knows I'm married. But it might not be officially documented in the record. So it's important to pay close attention to that and take the necessary steps to make sure your dependents are on the award. Absolutely.
And it changes over time, right? Everyone's life changes. Mm-hmm. People get married. Sometimes people get divorced. People have kids. And so VA, as with a lot of things, is often not up to date. And so, as you mentioned, it's critically important for veterans to check their award letter and make sure that their current situation is reflected on their award. Have they had a new child since the last time that VA issued an award? Has that child been added? Did their marital status change? Those things really factor into, one, making sure that benefits going forward are accurately compensating you to the maximum amount allowed under law, but also if something is inaccurate, making sure that the veteran catches it and corrects it with VA, because they want to make sure that they're avoiding potential overpayments that could be created from being incorrectly or overpaid. So that's sometimes just as important as making sure that veterans receive the maximum amount allowed, is to prevent them from being overpaid and having to get a bill to repay, or having their benefits reduced to repay something that's owed back to the government. A couple other things, you had mentioned these regarding forms. File the VA form 21-686C. This is the standard addition, subtraction, dependency form. It can be filed even before a veteran's eligible to receive dependency, which is another key point. A veteran might be combined at a rating of 10% or anything less than 30%. And so they haven't reached the threshold for dependency benefits yet. But it could be a good strategy to submit the form with dependency information. And so in theory, the second that VA grants the benefit that allows them to become eligible to cross the threshold to receive dependency benefits, boom, VA has all the information it needs to just automatically grant dependency with the award.
They should.
They should. We talked about this form too, 21-674. Again, this is the form for veterans to review, complete, and submit if they wish to continue on with dependency benefits for a child who is over 18 but is continuing on with their education in some way.
Once you have your dependents on your award, it's best to review your award annually just to make sure that you're keeping up with the changes and you are preventing any negative outcomes, like Mike talked about, overpayments, or missing out on benefits that you deserved.
Tinnitus is one of the most common service-connected disabilities, so it's no surprise that one of our most popular topics and videos from 2020 was VA disability benefits secondary to tinnitus. We thought we'd update that video and provide additional information on the topic. Dallas, can you start us off and walk us through what tinnitus is?
Yes, so tinnitus refers to a perception of a noise or a ringing in the ears. This is commonly a symptom of another underlying condition like hearing loss, an ear injury, or a circulatory system disorder. You can have some other symptoms like ringing or buzzing, roaring, clicking, hissing, or humming. So it's pretty broad, like what people could be hearing in their ears. And it's not a life-threatening condition, but it can cause some significant impairment in your functional abilities.
Yeah, absolutely. And there are, frankly, numerous causes. Some of those, though, you can probably imagine are relatively prevalent and frequent in service. And so things like gunfire, machinery, armored vehicles, aircraft, head trauma, combat environments, all these sorts, and that's just a non-exhaustive list, of course. All these things frequently happen and occur in service. It's hard to really escape them when you're in service. Right. And for many veterans, that results in a diagnosis of tinnitus. TBI is another big one. Like we said, head trauma. This can cause a veteran to develop the ringing in their ear, the tinnitus. Mm-hmm. There are other things, other factors, of course, like age-related hearing loss, earwax even, changes to the middle ear bones. There are various factors, but what I've seen primarily is, combat service-related factors such as, noise exposure linked to artillery fire, gunfire, just heavy machinery, things that occur day to day for veterans that are in service and that they can't really avoid.
Yeah. So tinnitus is obviously pretty common in our service members and veterans. So how is it rated would be our next question. Yep. The governing regulation for tinnitus ratings is 38 CFR section 4.87. And tinnitus does currently have its own diagnostic code, 6260. And when awarding tinnitus, it doesn't matter if it's in one ear or both ears. VA only assigns a 10% rating. So if you had just one ear, 10. Both ears, 10. But in some rare cases, and very rare, I must say, VA might give a higher rating that's extra scheduler. So I want to note, though, that VA has proposed to change the rating system to eliminate standalone tinnitus ratings. It would instead be a symptom of another condition. So this can change how secondary conditions are claimed, but they should still be compensated.
And to be clear, this is just a proposal as of right
absolutely,
now, right?
Yeah.
Although it does look like it could be finalized on the horizon. We don't know exactly when that might be, but it's something to keep in mind that this is out there. Veterans who have claims already filed or that are pending on appeal wouldn't be impacted by any change to the regulation.
Exactly. And CCK is obviously monitoring this very closely, and we'll have some information should there be any changes.
Absolutely.
Yeah.
So as you said, tinnitus is capped at a 10% rating, but there are other ways that veterans can see an increase in their overall compensation disability picture that result from disabilities linked to tinnitus. So what are we talking about here? We're talking about secondary service connection. The concept essentially of secondary service connection is that if a veteran's service-connected disability causes or aggravates another condition, then that secondary condition can be linked to service and thus service-connected by virtue of it being caused or aggravated by tinnitus. And so, a common example that I've seen is that a veteran is service-connected for tinnitus, and as a result, they develop depression. You can imagine the constant ringing in your ear over a prolonged period could potentially lead to anxiety or depression, number of other different conditions. But if the veteran can provide medical evidence, which is critical to show that the veteran's secondary condition, in this case, anxiety or depression, is caused or aggravated by service-connected tinnitus, then the secondary condition can be service-connected, and a separate rating will be awarded for that secondary condition. And so that can increase the veteran's overall disability picture by adding additional conditions that are independently rated, even if tinnitus is by itself capped at 10%.
Right.
Yep.
Yeah. And another example could be migraine headaches. This is a really common one due to tinnitus as well. And migraines they're characterized by intense pain, nausea, vomiting, and sensitivity to light and sound. Some research shows that up to 27% of people with tinnitus are also experiencing migraines. So another really common thing, and this is another way to really bump up a rating if you were service-connected for just tinnitus at 10, because a migraine condition can be rated up to 50%. So it can be pretty huge.
Now, another secondary condition that we see less frequently but does appear from time to time is something called somatic symptom disorder. This involves excessive focus on a physical symptom, and it causes oftentimes distress or impairment. This is a symptom that is often secondarily linked to tinnitus due to the kind of constant ringing nature of tinnitus in one's ear or both ears. And so this disorder is something that is, if diagnosed and granted, awarded separately. A separate rating is awarded for it. And therefore, as we were talking about a second ago, allows for an alternative path for veterans to be further compensated and really have the full scope of their disability picture accounted for due to service-connected tinnitus. Additionally, there are many studies that show that sleep disorders are conditions that are oftentimes linked to veterans who have underlying diagnosis of tinnitus. And so this can include sleep apnea, it can include insomnia. Various different types of sleep disorders can be linked to tinnitus. And if that is the case for you, consider filing a separate claim for service connection of those conditions linked secondarily to tinnitus. And again, as we've been saying all along here, if granted, those sleep disorders would be rated separately from tinnitus and allow for additional compensation.
Mm-hmm. And this isn't an exhaustive list. This is just some common examples that we see day to day in our practice.
Exactly.
Yeah.
Yep.
And so when we're filing for secondary service connection, there's some things that you need to have before you go ahead and file. So number one, of course, would be a diagnosis of the secondary condition. Sometimes, like Mike talked about, tinnitus can cause some anxiety and depression, but that alone may not be enough. You would need to have a clinical diagnosis of a mental health disorder in that case. And that's going to also require, as would any other claims, medical evidence that at least alludes to or shows a link to the claimed condition and your service-connected tinnitus, as we're talking about now. And some options that we can submit otherwise are treatment records, physician letters. Maybe your private physician can give a nexus opinion. Also, veterans can submit lay statements talking about their own experience with their symptoms. But also what could be helpful is any medical literature that shows some connection. We talked about a few numbers today that we've seen in the medical literature. So anything like that could be supportive for a claim and enough to get VA to trigger their duty to assist and get an exam.
Absolutely. Those are all great practical tips. One other thing to consider is a veteran's MOS or military occupational specialty really matters in these cases because VA has in its manual a list of different MOSs and it categorizes those by level of noise exposure. And so depending on what a veteran's MOS is, VA will list and categorize the level it deems to have, for a normal veteran or average veteran, to have been exposed to noise in that circumstance.
Right. And if I could add, even if it's low exposure, it's still, you're going to have the hazardous noise exposure conceded, even if it's low,
exactly.
a low level. Yeah.
So that's a great starting place for a lot of veterans who don't know where to look. Again, it's in VA's own adjudication manual, and it's a piece of evidence that sometimes VA overlooks and should be pointed out in a legal argument or a legal brief to show that this veteran was very likely exposed to high levels or even low levels of noise exposure, and as a result of that, in-service noise, tinnitus likely developed. Mm-hmm. So good practical tips. We have plenty more information on the topic at our website, cck-law.com, and please don't forget to like and subscribe to our channel. And leave a comment below if you'd like us to discuss any future topics in another episode.